renewal extension. If the tenant is to be granted a right of renewal or extension, the right must be specifically set out in the offer to lease. This right is usually exercised by notice in writing by the tenant to the landlord, given within a certain specified time frame, for example, no earlier than 9 months and not later than 6 months before the expiration of the term. Often it will provide that it is only exercisable in the event that the tenant has duly and punctually paid all rent under the lease and observed and performed all of the terms and conditions under the lease on its part to be observed and performed, or that it is the original tenant which must exercise the right of renewal or extension, and that if the lease has been assigned, the assignee is not entitled to such right. The amount of basic rent to be paid during the renewal term or the extension is usually to be determined by agreement between the landlord and the tenant. In the event the parties cannot agree, there must be a mechanism for it to be determined, failing which the renewal extension provision will be void. The normal provision is to refer the matter to arbitration, pursuant to the Arbitration Act of British Columbia. In some instances, there will be a referral to 3 arbiters. It is my recommendation that the matter be referred to 1 arbiter given the cost. You need to consider how the costs of arbitration will be paid. If the provision is silent, the arbiter will make the determination as to cost allocation. You may wish to consider inserting a provision whereby each party bears its own costs and splits equally the cost of the arbitrator. A common provision included in such a clause is that the basic rent payable for the renewal extension period will not be less than that paid during the last year of the term. The renewal extension will be on the same terms and conditions as the lease, except for any further right to renew, extend, unless there is a further right that there will be no leasehold improvements, no rent inducement or fixturing period. If there are any rights personal to the tenant, such as restrictive covenants, the renewal provisions must specifically state that they are carried forward. There is a difference between a right to renew and a right to extend. In the case of a renewal, it creates a new lease. In a renewal situation, there is a risk that the original tenant's liability will cease on the expiration of the term. Rights personal to a tenant, such as a right to purchase, may not continue during the renewal term. It will be necessary to word a renewal clause so that such rights continue. Given that a renewal creates a new lease, a renewal lease agreement should be entered into. For your information, in a renewal lease, it is necessary to include demising wording as contained in a lease. An extension is a continuation of the current lease. A default under the original term will continue to be a default during the extension term. This will not be the case if it's a renewal lease. An extension is probably better for a tenant as it is a continuation of the existing lease and all of its rights will continue. Signage. The landlord may have a signage plan for the building project. This may be in conflict with the tenant's requirements. In the case of a national tenant or franchisee, there is usually standard signage that is required. This will have to be negotiated between the landlord and the tenant. There will be competition for space on pylon and monument signs and on the exterior of a building. Depending upon the tenant, this may be critical. It is preferable from the tenant's perspective that if the tenant has its own signage program, it be added as a schedule to the offer to lease, whereby the landlord approves at the outset such signage. This will avoid any disputes as to signage which might arise in the future. You will also have to consider the costs being charged by the landlord for signage. Such costs are usually made for the tenant's signage on common pylon or monument signs. J. Measurement standards. The method by which the area of the premises is to be measured will have significance for the determination of the tenant's proportionate share of operating expenses and taxes, and for other matters as noted previously. The lease document itself may contain a specific provision setting forth how the premises are to be measured. There may be, page 24, adopted third-party measurement standards such as those of the Society of Industrial Office Realtors, SIOR, and the Building Owners and Managers Association International, BOMA. BOMA standards are the most common in British Columbia. If acting for a landlord, it will be necessary to discuss the standard to be used, and if more than one category in a standard, the category is to be used. The current BOMA standards are as follows. 1. Retail buildings. This is standard methods of measurements as ANSI BOMA Z 65.5 2010. 2. Industrial buildings. Standard methods of measurement ANSI BOMA Z 65.2 2009. There are two methods of measurement, being the exterior wall methodology and the drip line methodology. 3. Office buildings. Standard methods of measurement, ANSI BOMA Z 65.1 2010. There are two methods of measurement, being the legacy method and the single load factor method. 4. The gross areas of the building. Standard methods of measurement, ANSI BOMA Z 65.3 2009. There are two methods of measurement, being construction gross area and exterior gross area. This will be applied to buildings containing various types of occupancies, including office, retail, industrial, single and multi-unit, industrial, hospitality, entertainment, and institutional buildings. You can find the BOMA standards at www.boma.org and look for standards. K. Parking. The tenant may require a certain number of exclusive parking stalls, including handicap stalls, depending upon the nature of its business. Certain retail operations, such as financial institutions and pharmacies, seek stalls close to their premises and are very specific about seeking handicapped stalls. A tenant may also want a covenant on the part of the landlord not to reduce the parking from that at the commencement date of the term. This is of particular importance to retail and fast food tenants. It is preferable for the tenant from the perspective of taxation, for example, those imposed due to TransLink, to have parking set out as part of the leasing package provided to it and the cost thereof factored into the basic rent. L. Deposits. Security deposits. Prepaid rent. If the tenant is paying any money, is to be applied on account of prepaid rent or to be held by the landlord as a security deposit, they should be set forth. It is preferable to describe them separately. This may be important should the tenant declare bankruptcy and the trustee lays claim to a deposit, whereas it can be argued that no claim can be made for the prepaid rent. The offer to lease should set out the amounts and when they are to be paid. The offer to lease should also set out how prepaid rents are to be applied. If the tenant is unable to provide cash, alternative forms of security can be provided, such as a letter of credit or an indemnity or guarantee. M. Assignment or subletting. Under an assignment of lease, the tenant assigns its right an interest in the lease and the premises to a third party, called the assignee, for the balance of the term of the lease. The assignee steps into the shoes of the tenant and it becomes the tenant of the premises under the terms and conditions of the lease. Normally, the tenant remains liable for the obligations under the lease. The assignee will pay rent to the landlord. Under a sublease, the tenant transfers less than the balance remaining under the term and it becomes the landlord, called the sublandlord, or to its subtenant. A sublease may include all or a portion of the premises. The head landlord has no direct legal relationship with the subtenant. The subtenant will pay rent to its sublandlord, the tenant under the head lease, and the sublandlord will be responsible to pay rent to the head landlord. The offer to lease must set out any restrictions on assignment, subletting, or other dispositions, such as concessions or licenses, by the tenant or pertaining to a change of control of the tenant. The landlord will want control over such rights, as it will not want persons not approved by it in occupation of the premises. The tenant will not want any restrictions. The strength of the parties will determine the result. It is not uncommon to have the landlord's right of approval not be unreasonably withheld, with a list of circumstances which are deemed to be reasonable, such as if the tenant is in breach of the lease, if the assignment subletting use of an existing tenant of the project, to an existing tenant of the project, or if the proposed assignee has no experience in the business of the tenant for which the lease is being assigned or sublet. There may be exceptions for assignment or subletting without consent, such as to a parent, to a subsidiary, or between affiliated parties. Special consideration should be given in the case of franchise situations. Some franchises provide that the franchisor will enter into the lease and then assign the lease to its franchisee. In some situations, the franchisor will remain as the tenant under the lease, but will sublet the premises to its franchisee. In these situations, the franchisor tenant will require the right to assign or sublet without the consent of the landlord. Some leases provide that if the tenant asks the landlord for its permission to assign or sublet, the landlord has the right to terminate the lease. This is usually detrimental to the tenant, as it means that the tenant may not be able to sell his business as an ongoing concern if the landlord can terminate the lease. Also, some leases provide that if the tenant sublets all or a portion of the premises, the tenant has to pay to the landlord the increase in rent that it is receiving from its subtenant over the rent it is paying. A change in control of the tenant will also likely be restricted. A change of control, if not restricted, can result in persons not approved by the landlord taking control of the tenant and therefore circumventing the restriction on assignment. And we have a graph here. Okay, it says rights and interests in premises. So lease, tenant. Assignment, that is the balance in lease term transferred to assignee. And then sublease. We have, so the tenant transfers less than the balance remaining under the term and becomes sub-landlord of subtenant. And then we have here rent. So under a lease, it's the tenant pays rent to the owners. Assignment, the assignee pays rent to the owners. And then the sublease, the subtenant pays rent to sublandlord original tenant. And demolition. If during the term it is the landlord's intention to demolish the building in which the premises are situated, it will require a demolition right in the offer. The terms of such demolition right might be set forth, including the notice to be given. If the tenant is to receive compensation for its improvements, the formula for the compensation must be set out. This provision is becoming more common given the older buildings in Metro Vancouver and the amount of ongoing development. A tenant may negotiate that the landlord cannot exercise such right during the initial term, but is free to do so during a renewal. Relocation. The landlord may be interested in reserving the right to relocate the tenant to other premises within the project or other premises it owns adjacent to the project. This will enable the landlord to reconfigure the project, or if the tenant occupies only a portion of a project or floor, to relocate the tenant to permit the landlord the ability to consolidate areas and be able to lease larger premises to another tenant requiring a larger area. The relocation clause may contain a financial obligation on the part of the landlord to the tenant. Sometimes, if the landlord exercises such a right, the tenant may reserve to itself the right to terminate the lease. It is usual that the relocation must be to premises of similar size, fixturing, and visibility. This may be of more importance to a retail tenant, page 27, than to an industrial or office tenant. In the case of a retail tenant, its visibility and access to the premises may be significantly impaired by such a relocation. It is common that on a relocation, the new premises will be provided on turnkey basis. Restoration. Upon the expiration of the term or earlier termination of the lease, the tenant may be required to restore the premises to the condition they were in prior to the commencement date. This will require that the tenant remove all improvements made by it or for its benefit at its cost, or to repair any damage to the premises caused by such removal. This can be quite a significant cost to the tenant. The tenant will attempt to negotiate the exclusion of such a provision or restrict its obligation. Maintenance and repair. The respective obligations of the parties to maintain and repair needs to be set out. In case of the landlord, the financial responsibility will also be a determining factor. Based on a single tenant building, it is imperative that the obligation and the cost be specified. Normally, the landlord will be responsible for capital items, the cost of which may or may not be borne by the tenant as part of the operating costs. If the HVAC system, for example, is exclusive to the tenant, it may be that the tenant will be responsible to repair, maintain, and replace the system at its cost. If that is the case, the landlord may require that the tenant enter into a maintenance service agreement with a reputable service provider and provide proof to the landlord on a regular basis that the unit is being maintained. And class discussion. What is quiet enjoyment? Quiet enjoyment is a misunderstood term. It does not mean that a tenant is entitled to an absence of noise. The covenant of quiet enjoyment means that the tenant has a right to exclusive occupancy of the premises without interference by the landlord or anyone claiming through the landlord. It also requires that the landlord has the requisite right, either as the owner in fee simple, a beneficial owner, or a tenant under a head lease, to be able to lease or sublease the premises to the tenant. There are exceptions to this right, such as the landlord's right to enter for purposes of repair and inspection. For there to be a breach of the covenant of quiet enjoyment, the tenant's right of exclusive possession or right to access the premises must be denied. For example, the case of Stearman versus Powers, 2014, BCCA 206, dealt with the situation where an unpleasant odor from the building's HVAC system entered the premises. The tenant claimed that this was a breach of the landlord's covenant of quiet enjoyment. The court held that the odor was not caused by an act of or omission of the landlord and was not of a grave and permanent nature, and therefore there was no breach. The tenant's right of exclusive occupancy without interference was not denied. The odor did not create a danger to the tenant's business, and the tenant did not close its business. It is also to be understood that the landlord's covenant for quiet enjoyment does not give the tenant protection against nuisance from other tenants of the project or adjacent owners or tenants unless the landlord actively participated in or enjoyed the nuisance. Or encouraged the nuisance. Enjoy the nuisance. All right, that's enough for now.